Welcome to the Legal Academy, Episode 2. My name is Orin Kerr. I'm a law professor at the University of California at Berkeley. My guest this week is Jamal Greene, the Dwight Professor of Law at Columbia Law School. Jamal has been a professor at Columbia since 2008, taking a quick path to Columbia after graduating from Yale from law school in 2005, clerking for Guido Calabresi and Justice Stevens at the Supreme Court. Being a fellow for 1 year at NYU and then joining the tenure track faculty in 2008. And I think I can say Jamal has just from the get-go done really impressive work in constitutional law, publishing publishing terrific articles in the top law reviews and doing a lot of it really sort of immediate, very quickly reaching just a really high point in the academic world, really establishing himself as one of the top constitutional law scholars today. So Jamal, welcome to the Legal Academy.
Thank you. Good to be here.
All right. So I wanted to start with the research question. You write on what I think of as big con law topics. So you write on topics like, the nature of rights and interpretation at the Supreme Court. And those are topics which I think a lot of law professors want to write about or certainly are interested in, but find it hard to approach because there's just so much scholarship already in the field. How do you think about going into constitutional law as a topic? Like, how do you go about writing and finding something new in that field?
Thanks. It's a good question, and I don't have the best answer to it because it's not something that I've kind of. It wasn't a strategy, let's say, and I think when I started out in many years ago, I didn't start out thinking, oh, look at what Dworkin's doing, look at what Tribe's doing, look at what Akhil Amar. I'm gonna beat them. That wasn't really what I did, and I wouldn't recommend that anyone try to do that. You can't really start with the big idea or the big set of ideas. I think that's, I guess, one thing I'd say is, I just wrote about what was interesting to me as I took, I wrote a lot in law school. And then subsequent to it, kept writing even when I was clerking a little bit, and just little things that just kind of stuck with me. I would just write about them, and it turned out over time, when I look back, it was okay. So I guess I'm interested in interpretation. I guess I'm interested in the nature of rights. It wasn't something that occurred to me from the start. So I guess one thing I'd say is. Is again, you can't start with the big idea. Part of how I think I got from smaller ideas to bigger ideas is just writing a lot. You can't just kind of sit down. At least I can't. Maybe some people can, but I can't sit down and think, okay, I'm going to write a really awesome article. I'm just going to sit here. Right, until my idea for a 40,000 word law review piece shows up in my head, and then when it shows up, then I'll be, that's not how idea formation works. And so I kind of forced myself early on to write a lot, and part of that goes against some of the advice that I think people, especially junior professors, sometimes get about doing symposium pieces.
Mm-hmm.
For example, don't let something take you off your research agenda. Don't write too much. Don't quality over quantity and so forth. And those all sound very good, but I think in my case, I think forcing myself to have a deadline and to produce something made me, and to produce something small, right? Not something big, but something, just a little contribution here or there. And then over time, you get, 6 of those pieces, and you look back and you can string them together. They're a mosaic, you might say, that you can kind of string together and say, okay, here's my idea. Here's what I'm really thinking about. The other thing, I guess, part of you said, how do you come up with kind of fresh ideas? I don't think there are that many fresh ideas, and I certainly don't have them. So nothing I've written is something that only I have written about. Now, usually when I start the piece, I think I'm the only one who thought, oh, no one's ever thought of this. And of course you do a little work and you realize, of course, lots of people have thought about it. There are no new ideas, especially in constitutional law. But there are, in workshops, sometimes people say, this question's been asked, but it hasn't been asked by me yet. So I'm just going to go ahead and ask it anyway. I kind of treat things that way when I write. Um, you're part of a conversation, and so it can't be, the criterion can't be no one's ever thought of this thing. It's got to be am I communicating the idea in an interesting way is part of it as well, or am I communicating it to a slightly different audience than the previous audience, or audiences have heard this idea before, right? So it's I think trying to write slightly differently. I don't think I write the way most law professors do. So, and that's part of I used to be a journalist, and so part of it is being a little bit less formalistic in the way that I communicate things.
Yeah, you have a if I you have a very nice style in your writing. It's very readable, very accessible. I think it's a great style.
Well,
Really
I
like it.
appreciate that. I don't think that's shared by everyone, but I do think that meaning the reaction. I don't think is shared by everyone. But I do think that you can read something. You read something that's been written by Kierkegaard, and then you write it in a way that can be understood by the New York Times reader. Then you've contributed something, even if it's not a new idea.
So I want to focus on this idea of being part of the conversation. So who do you see yourself as writing to? Who's your audience if you're having a conversation about ideas that have been in the in the mix for a long time? Are you writing to other professors? Are you writing to judges? Are you writing to sort of the academic community? Do you have a sense of if there's this conversation and there are ideas that have been expressed in some way before and you're putting kind of a new spin on them, who is it who you're speaking to?
I think that changes over time, and by the piece. And for me, it certainly has changed over time. I think at the start, you're writing for other law professors. At least that's who I have in mind, and certainly in my earliest work. That those are the people most likely to read your work. If you're writing in student edited law reviews, and if you're not famous, the only people who are going to read your work, if anyone, are maybe some of your students and some of your colleagues and some other people in your field. And so, as you're establishing yourself, you want to show that you can make the kinds of moves that are recognizable to people who've been in the field for a long time as interesting moves. So when you start out, it's just, okay, here's one interesting move. And then you get someone's attention and say, okay, this person is capable of making an interesting move. You don't have the next 4 or 5 moves yet. You work that out over time. But again, to start, I think it's other law professors, and it's not the whole law professoriate. It's a smaller chunk. And when you start, it's a much smaller chunk. I sometimes, when talking to entry level people, and I feel like I experienced this myself. You're on the entry level market. You've got all these really smart people reading your work, and then like you get hired, and then like the next day, you spend the rest of your career is like getting back to the point where that many smart people want to read what you wrote, and that's it's a slow climb. At this point, some years into things. I don't think, law professors are part of my audience, but my students are a big part of my audience at this point. And I think I'm working, the primary thing I'm working on right now is a book, and it's a trade book. So the audience is, smart people who aren't necessarily lawyers, who aren't necessarily law students or academics, but people who are interested in politics or interested in law and want to hear something from drawing on expertise from the law world, but that speaks to some topic that they find interesting in their own lives or they've observed in their own life.
So this brings up two different directions I want to take you in. One is this idea that you mentioned of sort of thinking about articles as moves or as a combination of moves. I was hoping you might be able to say a little bit more about that, because I think a lot of professors think that way, or some professors think that way, and those that don't think that way are just like, I have no idea what that means. Like, they're just like, what do you mean you're moving? What's going on? How do you think of it when you think of like an individual article? How are you seeing it? I mean, are you identifying this is the move I'm making in this article, or is it not that sort of conscious and explicit? Is it more just implicitly that's what you're doing when you're writing?
Well, there's a few different kind of stages, I think, of a piece. You've got the piece that where you might describe it as, someone else could have written this piece if they had time to write it. Right. Um, that's kind of like, I would call that like the student note sort of level of piece. Whereas it's not that you're a genius, it's that you took the time to say something interesting. That time is valuable, right? So it's you're making a contribution, but it's a particular kind of contribution. Then there's I could have written this, someone else could have written this piece if they knew more, right? Not if they took the time to learn, but they just don't have the same expertise or set of experiences that you have. So they can't necessarily write the same piece. That's your kind of your entry level piece, right? I've learned something. I'm going to show you that I have a seat at the table because I know something that you don't necessarily know. And then the next kind of stage of piece is I'm synthesizing this information in a way that you haven't thought about synthesizing it before. You wouldn't, other people have taken, I guess by way of example, in my own career, a lot of the early things I wrote about had to do with originalism. And
Mm-hmm.
I always struggled to kind of explain what I write about originalism, because I'm not an originalist. But I'm also not, and people describe me as a critic of originalism, and I am in a certain way. But I'm not. I think it's fine to be an originalist. It just isn't what I am. And my work is kind of quasi sociological. Definitely, almost. I'll even say pseudo sociological, in that I write about the structure of legal argument, and I write about the fact that we are originalist is a fact, and it's a fact about the legal culture, and it's an interesting fact because it's not generally true, at least not in the same way, in other legal systems. And so that's something that's like, why like, how are we justifying that? What's our audience? What are we trying to get out of that? So the move would be a methodological move to say, I'm going to approach this sociologically or pseudo sociologically, since I'm not an empiricist, or at least not a trained empiricist. Whereas another person's move might be to say, I'm going to take this entirely from the internal perspective of this legal theory and tell you why what's been said before is not quite right, or should be enhanced in some way. So
It seems like the move is sort of the meta perspective of what you're trying to do, sort of taking a step of level of generality back
yeah,
about like what it is you're trying to do by writing the article you're writing. Is
yeah.
that fair?
So changing the level of generality, is a move. A different application would be a move, right? Or a different institution. So let's do originalism in the executive branch, or
Right.
so that's what I mean. And I think certainly in the early stages of one's career, that's what you're kind of looking for is how can we, it's not that it's a totally new topic. It may not even be that there's been nothing said about it, but I'm gonna grab onto a kind of slightly different direction than where most of the work is. And if people have already written about this 10%, I'm going to write about it 35%, right? And that's how I kind of think of it.
Okay. So you mentioned a couple of different types of pieces. You did a lot of symposium articles, as you mentioned earlier, and you are now working on a book, which I want to hear about to the extent you're willing to talk more about it and how that fits in.
I'll
But
even tell you where you can buy it in a few months.
all right, yeah, yeah. Well, but before we get to that, let me take it in two steps. I wanted to focus on your Harvard Law Review foreword. So you relatively recently, I guess, fall of 2 years ago, fall 2018, Yes. Published Writes as Trumps. You were invited to write the foreword to the Harvard Law Review. And that is, that's like a tremendous compliment, obviously a huge honor to be invited to write the foreword to the Harvard Law Review. And for those of you that aren't familiar with this, the Supreme Court issue of the Harvard Law Review, the first issue every year, is about the recently completed Supreme Court term, and the law review editors invite a prominent scholar to write the foreword, and then there's some additional articles that are invited as well. I want you to. I was hoping you could talk about the experience of writing the foreword. So, how does it work in terms of timing? Did you feel like that was a format that sort of was best, well suited for you, or did it not work for you? Because at least when I've heard other people talk about it, it seems like the invitation comes, if the invitation comes in the spring, come up with your 80-page article or your 60-page article, or I think in your case, a 105-page article in a very short window of time about like the prior term. And how did you go about that? Take us through kind of the process of how you wrote that article.
So I'll do that and take you through a little bit, but I think my experience might be different than a lot of other forward writers' experience for a couple of reasons. So one is they asked me in December. I think that in the past, or in many past years, it's been more like March. So that's a huge difference. I mean, just being able to write, because it's due like it was actually the due date is before the end of the term. Right, so there were cases that several of the cases, in fact, almost all of the cases, one or two of the three cases that I focused on in that piece had not been decided when the piece was due. Right, so that's a really unforgiving deadline, and if you got it in March, it's just sort of impossible to do something well in that space. So I had more time than most.
Okay.
The other factor for me is the topic. So I'll say a couple other things. So one is I'm pretty, compared to other forward writers, I'm pretty early in my career. So there are still things that I would like to say that I haven't said yet. And so that's to my advantage in that here's a nice forum for exploring some ideas I haven't quite explored. Most people, especially if they're the standard kind of common law generalist that gets asked to write the foreword, by the time you're asked, you're done with ideas, and so you're just kind of regurgitating what you've written before, but in the grand style, as opposed to just saying it, I guess. But for me, it was actually something I'd written a little bit about it before, but I was able to write a reasonably fresh idea for me. It was reasonably fresh in part because this book I'm writing is about the same topic that the foreword is about, which is it's a critique of U.S. rights adjudication,
Okay.
and its kind of binary approach to rights, binary categorical approach to rights, and I'm calling for more nuance and something closer to Canadian style proportionality. I had already had the book contract and a very extensive book proposal before I was asked to write the foreword. And that was like literally a month or two before I was asked to write the foreword. I was about to get started writing this book, and the book is as I mentioned, it's a trade book. So, the way in which you write that, it's as important that you communicate and you get people to read the piece than it be like completely accurate from the perspective of a legal academic, right? So, you're crossing your T's and dotting your I's maybe a little bit less, or at least the dot is a little fainter on top of the I. And so that's a different style. And because you're sort of trading off comprehensibility with being true to, the integrity of the idea. So the foreword was actually a great opportunity for me to be able to write the piece as an academic, right? To say, okay, if I really wanted to write this piece as a law review article, how would I do it? And where I don't have to worry so much about whether it's going to sell, because it's not going to sell. It's just going to be put out by the Harvard Law Review. So it was well timed for me. And
then did you have a feeling that because several of the cases that you were talking about were not out by the time you had to submit your draft. Did you have a feeling that the enterprise was sort of not really about the Supreme Court term? Like there's this great article you may be familiar with. You may have read it before you wrote your foreword by Mark Tushnet and Timothy Lynch about the Harvard Law Review Forward Project. It was in Constitutional Commentary in 1995, and it's sort of a discussion of like what you can learn about constitutional law from the Harvard Law Review Forewords. And it does seem, as you mentioned, usually there's sort of senior scholars that are invited, and they've got their take on the law. And then you've got sort of a bit of a conflict between that and the idea of it being about the prior Supreme Court term, and that a lot of times what the professor wants to write about has nothing in particular to do with the term. And then in your case, it seems like who knows it was going to have a lot to do with the term because the cases weren't out yet. I mean, do you think of that as like an opportunity for leading scholars to kind of present their view of the world, or is it let's talk about the prior term? Or is it a mix of the two? Like, how do you think about that?
I think the criticism is right. I think it wasn't quite right in my case, and this is sort of maybe an additional point as to why I was differently situated than I think most people writing the forward is, because my piece was about the frame that the court and litigants put on cases, right? So in your world, so one of the cases was Carpenter, which is something from the criminal procedure world. And so the frame of that piece, it's actually turns out that Chief Justice Roberts kind of rejected the frame, right? But the frame of the case was, okay, so either we've got to like jettison the third party doctrine, right? Or we've got to apply it in this awkward circumstance that makes us feel uncomfortable and makes us feel like we're getting our privacy violated. And Roberts was kind of like, well, let's just be realistic about this. And that was kind of what I'm urging. But I can urge that even if I can say like, hey, and Roberts did what I wanted him to do, because we shouldn't think about this in these binary terms. We don't need to think about this thing solely in terms of these kinds of rules and categories. We can be more flexible and so forth. And the other two cases were Rucho, the partisan gerrymandering case, and Marshy's Cake Shop, both of which it didn't really matter how the court came out. Okay. It was really about the frame of the cases. But so for me, it was I just had to fill in some blanks for the Mad Lib at the end to see what the court actually said. But the criticism in general, I think, is if to the degree it's a critique, is right. In recent years, certainly, in recent years, I mean decades, the forward is not really about the Supreme Court's term. It's about the research agenda of the particular person writing the forward, or it's kind of a capstone piece for the author. Maybe that's okay. That part of that is, the kinds of people you get to write the forward are not typically writing from the internal perspective that the court is writing from. So if you just write a piece that says, okay, here are the moves that were made in these particular doctrinal areas. Here's what Justice Alito said. I'm going to fit this into the prior body of case law, and that's not typically the people they get to write the forward. Now, for better or worse, maybe there should be more of that, and that would maybe serve a valuable function for lawyers. But I think the way the legal academy tends to screen people makes it harder for someone who writes in that way to write the forward.
Yeah, so that brings up some bigger questions that I wanted to go to. In particular, kind of the background of people that become law professors. One important trend over recent years has been towards PhDs in various disciplines. You did not take that path, so you was a fellow for a year and then went straight in. What's your view of kind of what's the either the best way to do it, or how do you think about the trend toward PhDs? Does it depend on the field? So maybe in constitutional law, you clerked at the Supreme Court. Maybe a Supreme Court clerkship is like the PhD of a constitutional law generalist. How should we think about that trend towards PhDs? Is that a good trend, a troubling trend, or does it just depend?
I mean, I think it depends. I think it depends on the school. I think it depends on the field. Um, but I think on balance, it's probably at least the pace and magnitude of the trend. I think is not an especially welcome development. I think it's valuable to have people with training in other disciplines in law schools. I think it's essential, in fact, to have people with training in other disciplines in law schools. I don't think that should be everyone who is in a law school. In that we have, I think, I think the value that we add as academics to the rest of the university and to the rest of academia is that we are simultaneously talking to people. For me, that's people across the street, and so in this background, that's the philosophy building behind me. Uh, People across Amsterdam Avenue for Columbia, but for on any campus, people from the rest of the campus. But you're also talking to the bench and the bar, and you got to be having both those conversations at the same time. That's a really valuable space because you've got really important practice that is listening to you and that you're contributing to, and really important set of ideas that you're also contributing to and listening to. So I think there needs to be a balance. I think that there is a balance in the academy as it stands right now, but on the entry level, I think it's probably too skewed. Certainly at Columbia and schools competing with Columbia, it's too skewed, I think, in favor of PhDs, and it's not the PhD itself. That's not itself a problem. It's I think there's a kind of path dependency that happens, and people who are on the market, they look at who gets jobs and they notice that a huge chunk of who gets jobs have PhDs. Then it looks like the way to get a job is to get a PhD, and so more people do that. And then you've got a chunk of people who know that they want to get a job in law, but they're doing a PhD in economics or PhD in history, so they're already writing. Their dissertation is to be placed in a law school, right? And so
Right.
that person who's been thinking for 5 years about their research agenda at a high level at a elite institution and knows that they're going to do that, so they're talking to law professors too, competing with on the entry level market with someone who was at Skadden for a couple of years and did a high level clerkship, maybe wrote a piece in law school. Those two people could be equally brilliant or equally likely to have an impactful career in the legal academy. But you look at what they produce on the entry level market, there's not going to be any comparison between those people. And so that pattern just continues. So you hire the one with the PhD because they're the safer bet. And then the next person coming along says, well, should I go to Skadden or should I do a PhD? And oh, okay, well, I'm not stupid. And so I think that's
So is the dynamic you're describing? It sounds like maybe I have this wrong, but I think what you're saying is that the folks that are coming in with a PhD they've just spent more time gathering up their academic credentials and thinking of articles and participating in the scholarly enterprise, such that when they go on the market, that sort of critical moment of entry level ALS, like here we go, they've got a better package then that creates this big advantage for PhDs that may not be, maybe, but may not be as merited because of it's just like a time question, not a
well,
merit.
I don't want to take away from the people, the people who've done this successfully. It's not to say that they're not the best candidate, right? They've positioned themselves to be the best candidate, and they've worked hard to do it. And the people we've hired, people other schools have hired, are great. These are not bad hires. But I think I'm not confident that that on a 10-year window, let's say, that at the end of the 10 years, that person who got the PhD versus the identical person who didn't is going to necessarily be producing much better work. It's just that when you're making a prediction and you're relying on heuristics and you're relying on also the existing research agenda and the work, if you have it's the time and the saturation within the academic environment, that person is like what a tenured professor used to look like. like
Right.
someone who's been in that environment for a few years and sort of knows how to make the moves and knows what the ropes look like, is going to, again, a much safer bet. But the downside of that is then you don't have any lawyers on your faculty.
So that somewhat indirectly, I think, leads to an additional question about hiring, about the role of entry level hiring versus lateral hiring. So most schools try to have a mix between entry level hires and lateral hires based on, maybe there's some sort of sense that it's good to have both, or there's sort of various arguments for and against. Should schools, to the extent that they're running into the problem you identify, should they be focused more on lateral hires instead of entry level hires to kind of see which of those early promises play out? Does it, and one way of thinking about this is I've sort of wondered why do the top schools hire entry level at all? Why not just wait for to see who comes through in the lateral, sort of over time? And to the extent that there's this problem of like the early entry level moment where schools are making these judgments, and it may be 10 years later, oops, we didn't do that very well. Why not just focus on lateral hires? Do you have a sense, of what schools should do?
So I would hesitate to give a blanket assessment. I think it depends on the levels of seniority on the faculty, the existing faculty. It's going to matter a lot here. It might depend on the resources of the school. Entry level hires are cheaper than lateral hires. But to your question, I think that's an easier question, which is why, because I'm at a school that does a lot of entry level hiring and does more entry level hiring than some of our peers. And I think the best reason, I think there are two good reasons to do that. One uh, is especially if you have a big faculty, um, trying to get consensus on lateral candidates can be really hard. It's easier at the entry level when people are more willing to roll the dice, but when you're talking about a tenured hire, there's always going to be someone who doesn't like their methodology or thinks that we should be hiring in their area and not this other area, or just doesn't like the person or whatever. It just gets more complicated at the lateral level. The second point, and I think this may be even more significant, is, and I don't think schools have fully internalized this empirical reality, but people who get hired at top law schools, and really any law schools at this point, are often in dual career families. That wasn't always the case. That's certainly the case now, and so having people, and so entry level people, they're often they may have, if they have kids, they're young kids, much more portable, and they're getting their lives started, and but by the time they're laterals, they've got the kids are in sports leagues and got their friends, and the partner has their career, and you've got to replicate that career in some way if you want to be able to bring them over.
Right.
It just gets, and just at a human level, it stops making sense. If you go to a pretty good law school and you have good colleagues and you have a perfectly good life, and then some school that's a few ticks up in the U.S. news says, oh, come and just destroy that life, so that you can get another half of a gold star on your forehead. That's not. I think that quite sensibly becomes less compelling for people. And so I think just the practicality of it. If you want to hire good people, you hire them on the entry level and give them tenure and hope to keep them there. That's the most straightforward path. Now, there are some risks associated with that, but I have, in my 12 years at Columbia, just my one example, it's rare. I mean, it's hard to get hired on the entry level. Those people are going to produce. They're going to produce, and they're going to produce good work. And so the downside risk is, for any school that's that's making some pretty strong judgments or difficult judgments at the entry level, it's not that much of a risk.
Um, so another topic that relates to this is the question of diversity in hiring legal academics. A lot of schools put a lot of emphasis on this, or at least try to put a lot of emphasis on hiring, focusing on diversity in various ways. Do you have a sense that schools are on the right path? Is there something more they can do, or schools not thinking about this the right way, or you know, just interested in your thoughts about what schools can do in this area that they're not doing.
So, I'll say two things, um, both of which might be slightly controversial, but maybe pointing in different directions. So, one is no, I don't think schools are. I don't think our, and I'll just speak to uh, the sort of, I'll say the top 25, top 30 law schools, um, who are more or less looking for the same kinds of candidates within bounds. I don't think our typical hiring criteria are well suited to improve diversity in the academy. I think, and here's the controversial part, at least to be controversial among my colleagues, I think we put too much weight on whether we like their work or not, their scholarship. Um, and that goes to any candidate, diverse candidates or not. But which is not to say that we should be hiring people whose work we don't like, but it's to say, like, if you've got a candidate, entry level or lateral is sort of easier to talk this through, and and the candidate is producing work that's getting noticed or that's having an influence on someone, and they're a very good teacher, right? And they are a very good citizen. Like, they show up at workshops, they represent the school well, they engage with their students not just as a teacher but as a mentor. That's a really valuable colleague, and to to reject that person because, like, they weren't playful enough or something, which is like the jargon that you sometimes hear, or they that what I was told in the entry level by one school that didn't hire me, he didn't engage, when I had coffee with him or whatever. That's a skill. It's a pretty idiosyncratic skill, like being playful and engaging, and being, winning the workshop
Yeah.
is a pretty idiosyncratic skill. It doesn't even travel outside of the legal academy, right? If you go over to political science, it's a just totally different set of norms. That needs to be cultivated, and I think for a lot of minority candidates, they just haven't spent enough of your life in that environment. Um, Even if you think it's valuable, on its, which I'm not sure it is. But it's going to bias you naturally if you put a lot of weight on that, unless someone is an awesome teacher but, like, isn't playful enough at the workshop. Like, you should hire that person, and that's not, I think, what our criteria actually look like.
And so there are two different ways of interpreting the idea of sort of liking their work. And I guess one was you read someone's scholarship and you're like, methodologically this is flawed, or this is premised on some assumptions that don't work. And another is more kind of the workshop culture style. And are you focused more on the workshop culture style or the former of their
so,
work? Because
so I think
one
it's
is substantive,
both.
more is the other sort of
No,
appearance
I think it's
style.
I think it's both. And you're right that they're separate. They're different things. But I think it's both. We have these big. So one thing is we have these big faculties, and as we get more and more specialized in various ways, um, we actually can't. I'm criminal procedure, which you work in, which overlaps with the actual Constitution, which I work on. I can't really. I mean, I can have a conversation with you about your work. I can read your piece, but even even in your work, tends to be pretty law oriented. And I like law. I read court opinions, and so even us, we have pretty good overlap, right? As legal academics go, aren't really working on this we'd be in different departments, on a different kind of faculty. And so to extrapolate beyond that, I think we actually aren't very good at evaluating the work of colleagues. I think some of us are, if you're in your field, obviously you're differently situated. But I think we're not as good as we think we are. I think at evaluating the value of the work of the scholarship in other fields. We can evaluate whether we like the moves they make, right? But that's not. I think I'm not going to say it has no that has no value, but it's you should. I don't think we should be hiring on the on the. It should be a very small part of the hiring process, and what value they will give to the to the institution, to the faculty, and diversity is part of that. Is it should be much more important and much more heavily weighted in the process, I think, than it is. Now, the other, go ahead.
No, no. One way this plays out, I think. I mean, I've definitely noticed entry levels that have done a fellowship, especially at certain schools, have mastered kind of this job talk style that you're talking about, this sort of the playful style, and they have like certain kinds of answers that have like academic sounds to them, whether there's substance behind that or not. And there's sort of like a training in the norms and a training in the style. I mean, it's sort of it. It always makes me sort of feel like when I was when I was a kid and I would be in some sort of formal environment, like a dance or something like that, and I was like, I don't know how to behave. I was an awkward kid, and then this is like the academic version, which tends to, I think, get so much attention in the hiring process, where someone who has the style tends to excel. And I think it's one of the reasons why the fellowships and the like are so important, is people sort of are learning the style, and that raises a question, I think, of like, should schools not have job talks as part of the hiring process? I mean, is just the job talk a bad idea? Because the job talk, after all, is like, it's a performance, right? It's a show us your style kind of thing. Especially, I think, in the lateral level, where somebody might have 20 articles or 40 articles or whatever. They're established scholars, and then they're called in to sort of give a performance. It is kind of a funny way of testing whether somebody can join the club. It's sort of it to me. It always felt a little bit more like a club. Like, do we like this person's style? Do they seem like they fit? It's almost like a fraternity sorority kind of thing, rather than an academic academic interview. Should we just get rid of job talks? Are they the problem?
So I don't think they're fully the problem. I think what you're talking about is, and I said they're different, but they're related. I think it does translate into the writing also. There's a style of writing as well that I think is also you say you said yourself said that's the substance, right? But I think discriminating between style and substance in writing, especially for entry level candidates, is pretty difficult. Uh, should we get rid of job talks? We definitely rely on them too much, certainly at the lateral level, and I've seen that time and time again, where it's like, this is an obviously good candidate, and but I didn't like how they answered that question in the job talk, and so there goes 20 years of teaching out the window, because you didn't answer this person's question, you didn't hear the second part of their question or something, and I think if you ask any person who does hiring for a living, or anyone who thinks about the psychology of hiring, would have a field day with the way that law schools, other departments also, but law schools, I think, are more performative than some other disciplines.
And then do you think that's explained by the point you mentioned a little bit ago, that just so many professors don't know the research, don't understand the research and the work of other people in the legal world, because we're so splintered that they focus on performance instead of kind of the substance of the work or the quality of the work? Or is there a reason why law schools are different in that regard?
Well, we're lawyers. I mean, we teach people how to advocate for things that they may not believe in, right? And so that is necessarily performative, right? You're selling something, and so traditionally we've screened for how well do you sell yourself, because that's what we're used to as a measure of competence as a lawyer, is you're good at communicating, you're good at the presentation. Now we can rationalize it by saying that also tells you something about teaching, which I think it probably does, but I do think that that's probably a big part of the difference with other disciplines, where where all the work, the people you're training in other disciplines, you're training them to be good on the page, right? You're training them to produce good research, whereas we're training people to communicate. And so we've got to, if you show that you can't do that yourself, that's a strike against you. So I think there's something to that. I just think, and I think to just step back from the is what is sometimes called clubability, right? Or do they seem like they're kind of like us? Is the standard that the overwhelming standard that is used in hiring, as opposed to this person is going to contribute to the institution that works for us, that we work for, and the students who pay us are going to learn from this person and find them valuable. That's and we also have anxiety about other faculties and our standards for tenure and so forth. So we want to be able to say no, it's really about the integrity of the work and the brilliance of the moves and blah blah blah. And I don't think it's irrelevant or unimportant. It's just for that to take that takes a back seat too much to what is the value of this person to this institution. Let's think about this in a concrete way about what are the outputs here.
Yeah.
If the outputs are reputational, well, that having a diverse faculty or someone who's really a superstar in the classroom and is producing work that, again, if you're producing work that no one's reading and that no one cares about, that's one thing. But like whether I think that this IP person's paper is good, I don't see what output that contributes to in a significant way.
Right.
It might make me like them more a little bit more on the margins, but it shouldn't be about like who am I going to have fun with. It should be about the institution itself. But the
Great.
other
So
point I wanted to make, though, I didn't want to.
no, go ahead, please.
Is and I think this is important also as we think about, because as you think about strategies for diversity, I think every institution that cares about diversity wants to improve diversity at their own institution, right? But given the various bottlenecks that we're talking about when we talk about minorities and sometimes women in particular elite professions, it's not always clear exactly to what degree is it a supply and demand problem, right? So if you look at elite lawyering, which is where we get our faculty from, the universe of elite lawyers is not diverse, and so is entry level academia. Let's say you can't do anything about the senior people, but is entry level academia, does it have a special diversity problem in relation to the pool of people it's drawing from? I don't see much evidence that is so, right? So in other words, I think entry level legal academia is at least as diverse as the elite legal profession is. Now, as we've just talked about, there are all kinds of ways where we can do better than what we do. I think we can do better than what we do. But as we think about what the strategy is, like peering harder at the paper that someone's producing is only going to get you so far. Peering harder at the pool, right, is only going to get you so far. It's really a question of how are people getting into elite law profession in general. That's a huge part of it. And then once you get to that point, we do have to ask ourselves, I think, and I think any school that's thinking about seeding, academics has to think about the trade-offs in terms of the relative value of people being in academia versus being elsewhere. Like if you told me, we've got 10 minority candidates, you can send the 10 of them to Harvard Law School, Columbia Law School, or send the 10 of them to work in, as public defenders or prosecutors. Should you send all 10 to the Harvard Law School? Surely not. Should you send all 10 to the prosecutor's office? Probably not, but I'd be more confident doing the latter than the former, just in terms of what the world needs. So, which is to say, again, it is a problem. It's a huge problem in the world. The degree to which it's a special problem for legal academia is one that I think we should think more carefully about than we do.
Okay. Thank you, Joe, so much, Jamal, for appearing on the show. It's been terrific, and I'm really looking forward to your book. The last opportunity, I want to just give you to tell us a little bit more about the book. What's it called? When's it coming out? And the like as our last thing to talk
So
about.
you can't pre-order it yet. I'm still in almost at the copy editing stage, but the title of the book is How Rights Went Wrong, and it's a story of how we got to the point where the U.S. is really the only country that frames its rights disputes, its adjudicated rights disputes, in as kind of purely interpretive questions. Or so that when we get a rights dispute, we ask, is there a right to this thing? And if the answer is yes, then the person probably wins. And if the answer is or is supposed to win, and if the answer is no, the person's supposed to lose. And so all the weight is on that interpretive question, as opposed to the weight being on, well, what's going on here? What's the government doing? What's it trying to do? Should we trust it? Do we have good reasons to trust it? Which is much closer to what most other countries do. And I think, and the book trying to tells the story of how we got here, and the ways in which I think it opens up a much larger gap between rights and justice than is necessary, and I think contributes to polarization because in order to win against you, if I'm in a dispute with Orin, I've got to show why I have a right and Orin doesn't, as opposed to saying, well, we both have rights and let's figure out like what the right answer is here in light of the fact that we both have valuable commitments to whatever we're trying to do. And that's a much more factually sensitive, much more contextually oriented approach that I think we could do a lot more to get to.
Great. And when's it coming out? Do you have a publication?
March of 2021.
Great, great.
So
Congratulations.
you've got some time to save up your 26.99 or whatever it'll be. To,
we'll do. Really looking forward to the book. Thank you for appearing on the show.
Thank you, Orin.